discussion. The panel tonight is sponsored by the Yeshiva University Center for Jewish Law and Contemporary Civilization. I'm Suzanne Lastone. I direct the center. It is also sponsored by the Jacob Burns Institute for Advanced Legal Studies and the Leonard and B. Diener Institute of Jewish Law at Cardozo. The Jacob Burns Institute is the cornerstone of the law school's pursuit of legal scholarship. It sponsors symposia, lectures, conference, and faculty research, and it was founded in 1987 by a former founding Cardozo board member and philanthropist, Jacob Burns. The Leonard and B. Diener Institute sponsors conferences, symposia, and scholarship specifically on issues of Jewish law. And they've been partnering, and we're very grateful, with the Center for Jewish Law and Contemporary Civilization, which, as many of you know, brings together scholars of many different disciplines in order to have a cross-disciplinary dialogue that contributes a Jewish legal perspective on issues in law and culture. And we have invited very deliberately tonight some of the graduate students from the Center in Jewish Law that we have, who we are delighted to see in the audience. As they know, we have been pursuing what might be one of the most difficult cross-disciplinary conversations, that is between lawyers and historians. Traditionally speaking, I think lawyers and historians tend to see things quite differently. And I'm going to articulate something that we put in the conference description when we invited our panelists, just to set out in probably very stark terms the different ways, in maybe even a little bit in an exaggerated fashion, the different ways in which lawyers and historians approach particularly the legal decision. And this is part of what we're going to be debating tonight. Generally speaking, historians, it seems, to me at least, tend to regard legal systems as objective social facts to be described by the outside observer. And so rules and decisions are generally viewed as responses to, and therefore reflections of, economic, social, and political conditions in the surrounding culture. In this way, law is, in a sense, another body of data for the historian. Those who are traditionally practicing inside law have generally maintained that law is not merely a set of rules or a functionalist response to the social world, but is rather a cognitive activity of a very distinct kind with its own language and logic that must be understood from within. Now, there's been, I think, in recent years, a fairly large rapprochement between law and history. They are attempting to meet somewhere in the middle of this dichotomy. And it is, I think, this particular dichotomy, right, whether this is an accurate description or something that has to be spun in some other different way, is exactly what our historians and legal historians are going to, and legal theorists are going to be addressing tonight. And with that said, I want to introduce what is an incredibly distinguished panel that we have with us tonight. Not in order of speaking, but just in order of my little notes. Professor Sam Moyn, who we are attempting to make an absolute regular, who is a professor of history at Columbia University, but not stated in his bio is that he also attended law school, and works primarily on modern European intellectual history with special interests in France and Germany, political and legal thought, historical and critical theory, and Jewish studies, and on the history of human rights. His publications include A Holocaust Controversy, The Treblinka Affair in Post-War France, which won the Sybil Halburn Milton Memorial Prize of the German Studies Association, Origins of the Other, Emanuel Levinas, Between Revelation and Ethics, winner of the Morris Forkosh Prize of the Journal of the History of Ideas, and most recently, The Last Utopia, Human Rights in History, and many of you heard Professor Moyn on this subject just a few short weeks ago. Professor Shai Lavi is senior lecturer on the Tel Aviv Law Faculty and director of the Taubenschlag Institute of Criminal Law. He received his doctorate from the Jurisprudence and Social Policy Program at the University of California, Berkeley. Dr. Lavi is the author of The Modern Art of Dying, The History of Euthanasia in the United States, which was awarded the 2006 Distinguished Book Award in Sociology of Law from the American Sociological Association. More recently, he has worked on the history of Jews and Muslims in Germany, focusing on the debate on animal slaughtering rituals, including Unequal Rights, Jews, Muslims, and the History of Ritual Slaughter in Germany, and Animal Laws and the Politics of Life, Slaughterhouse Regulation in Germany, 1870 to 1917. He has held visiting positions at Humboldt University and the University of Toronto. Richard Ross, who sits right next to me, holds a joint appointment in the College of Law and History Department at the University of Illinois at Urbana-Champaign and is co-director of the Illinois Program in Legal History. Ross has earned 3 degrees from Yale, a BA in 1984, a JD in 1989, and from the Yale Law School, and a PhD in history in 1998. He's received research fellowships from Yale Law School, the Institute for Social and Policy Studies at Yale, the American Historical Association, and there are quite a few more. I'm not announcing them. He's been a visiting scholar at the Harvard History Department, the NYU History Department, and he was a visiting professor at the University of Pennsylvania Law School, where we overlapped and met one another. Dr. Ross's recent publications include The Beginnings of American Law, A Comparative History, and Legal Pluralism and Empires, 1500 through 1850. And finally, Professor Assaf Lovsky, who is a professor of Tel Aviv University Faculty of Law. He's published articles and books on legal history, comparative law, taxation, and the sociology of law. His book, Law and Identity in Mandate Palestine, was published in 2006 and was the co-winner of the Shapiro Book Award for Best Book in Israel Studies. He's a former director of the Siegler Center for Interdisciplinary Research of the Law, former editor-in-chief of Theoretical Inquiries in Law, and a member of the editorial board of Law and Social Inquiry. So I really thank both these colleagues and friends for coming tonight and sharing with us their thoughts on a subject that I hope will engage us in a very interesting question and answer period after the panel. So we'll begin with Professor Sam Moyn.
Thanks so much to Suzanne, and it's good to see all of you again. I'll admit last time I felt a lot more expertise in addressing the topic. This time I'm going to speak more as a generalist. I'm not a legal historian by training. I've dabbled slightly in it lately, and I will defer to my colleagues. That's why it's probably best that I'm going first. I'm going to tell a big story about the relationship between law and history over time. It's going to be a story in 2 acts, and it'll be up to you to decide whether it's a tragedy or a comedy. The first act is one in which history begins as part of law and legal reasoning. And in the second act, it wins autonomy. Actually, I think surprisingly recently, and then can look at law from the outside in the way that Suzanne suggested at the start. Now, the premise is going to be that people don't think historically by nature. Indeed, there's a famous anthropologist named Claude Lévi-Strauss who claims that most societies have been societies without history. And what I'm going to suggest, and I'm going to look in particular at Jewish intellectual history, is that it's really as part of legal reasoning that at least part of our modern historical consciousness comes to the world and becomes part of our intellectual tools. Now, I don't want to overstate the case. Of course, in a traditional view, the Greeks discovered history. Herodotus is called the father of history, although frequently enough over the millennia also the father of lies. And there are going to be many sources for modern historical consciousness. But I want to zoom in at the law and legal reasoning as what might have been an essential, maybe the most essential incubator for modern historical consciousness. So to explain what I mean, I do want to dwell on Judaism, though I think most of what I'll have to say will apply to other traditions, especially ones in which legal interpretation is a key or even sole site of intellectual life, as in Islamic culture or even English common law traditions. Even compared to those roughly analogous traditions, though, Judaism is going to offer us a very illuminating case, since for a long time it has a very rich body of legal thought and legal reasoning, legal hermeneutic practices, but no discipline of history, no historiography. Now, some of you will realize that I'm alluding to a famous thesis offered by a late colleague of mine named Yosef Yerushalmi, who wrote a famous book called Zachor, in which he argued that law is bound up with the sacred and with memory. And because of the centrality of law, among other reasons, the Jews had no historians. They did in the ancient world, Flavius Josephus, and then they did again on Yerushalmi's account in the modern world after the 19th century, beginning in the 19th century. But in between, they had the sacred and they had memory. Now, I think this story is wrong. I didn't discover that it's wrong. I'm really going to be shifting my allegiance away from this late colleague to another a person, a late teacher named Amos Funkenstein, who, when he encountered Yerushalmi's thesis, said it's wrong. And he said it's wrong for the following reason. If you like, there's lots of historical consciousness in legal reasoning and in Jewish culture more generally. It might not take the form of secular historiography, at least for a very long time. But what if there could have been no secular historiography without the long incubation and the long traditions of historical consciousness within traditional Jewish practice, and especially legal interpretation and legal hermeneutics? So I'm going to tell you in this first part of my remarks Amos Funkenstein's story about how historical consciousness developed within Jewish legal hermeneutics. So first, Funkenstein argued there were these interpreters of the law who introduced an idea that, in their words, that Scripture speaks the language of human beings. And of course, at first, this plays a very restricted role in their reasoning. But if they relied on this premise, it's because they thought, or at least some people could begin to think, based on this formula, Scripture speaks the language of human beings, that the Bible's meaning could be different depending on where, and more important, when it's being read and interpreted. And the law could actually evolve depending on the situation of the interpretive community. Now, as Funkenstein followed the career of this principle, Scripture speaks the language of human beings, through history, he reached the Middle Ages, and he showed that this principle was used in ways to explain how God's commandments could change or at least be reinterpreted in drastically different ways over time. His great example was rules concerning the sacrifices, which in the Middle Ages were attributed to the kind of atavistic cultural practices of the ancient Israelites, and therefore could be superseded. This is what Funkenstein said about this general discovery he is trying to offer, that though Jews have no historical writing, they do have historical consciousness. They understand that they're different from past Jews, and they make this breakthrough intellectually through interpreting the law over time. This is a quotation from him. That God adjusted his laws and history to the capacity of men to perceive them presupposed a commitment to historical change. In other words, the legal interpreters began to understand in ways that all those societies without history hadn't, that there's cultural change over time. Now, what's the upshot of what I've just been suggesting, really just by recapitulating for you Amos Funkenstein's argument about the history of historical consciousness and its incubation within legal hermeneutics? Well, it's that without that incubation, the modern historian's epistemological sense couldn't have come into being, or at least not in the same way. If you like, then, in this first act, history begins as a part of law or as a byproduct of law or legal reasoning. Now, of course, the truth is more complicated than that, and there are going to be other sources for modern historical consciousness. But if this argument is right, law is a big one. But at first, history and historical consciousness is internal to it. Now let's turn to our current situation, where I want to suggest it might be a very good thing, not a bad thing, that history has in a sense been freed from law so it can look at it externally or from the outside. Now, I think Suzanne's right that there's a new rapprochement between law and history. I think there are some kind of mercenary reasons for that. A lot of law professors now being hired aren't being chosen according to the same criteria, and now it might really matter that they have a PhD from some other discipline like history. But why did that happen? Well, again, there are going to be lots of reasons. One big reason I want to toy with is the faltering of what I'll just call, in a very stereotypical phrase, the common law mind, into which for centuries Anglo-American lawyers have been more or less happily inducted. It's amazing. Any first-year law student, aside from civil procedures, still basically is inducted into the common law as his introduction into law. Let me explore a brief comparison between Judaism, as I've been discussing it, and the common law. As in Judaism, the common law mind has ultimately some very similar approaches to legal hermeneutics. They differ in the details, but they are often very similar in their ultimate purposes, keeping, if you like, a chain of tradition alive through time. And in the same way, I think, the common law involves lots of historical consciousness, even though lawyers don't typically write history. Now, it's true that unlike in Judaism, common lawyers didn't and don't believe their authority stretches back to divine revelation. The typical view in the common law would be that the common law comes from time out of mind. The origin couldn't be discovered. But in spite of that difference, the common lawyers have seen themselves, or did see themselves, in a chain of tradition. They were agents through which the law was supposed to work itself pure or be gingerly adapted by them to new circumstances, understood in new ways, but never discontinuously. And it's in part for that reason that in a classic essay of almost 50 years ago now, the famous historian John Pocock argued that the common law, with its devotion to evolution, tradition, and so on, was actually the source of modern political conservatism in the form of Edmund Burke's political theory. So my point here, roughly, is that as with the Jews, common lawyers weren't professional historians, but like them, were a kind of incubator for historical consciousness. Now, what's changed? I think our current situation follows from the fact that recent circumstances have made clear how limited the versions of historical consciousness in those old traditions like Judaism and the common law were. If you like, they weren't that historical. And people who were committed to understanding things in their place and time had to work with history, so to speak, on their own or outside those traditions. So it's true that we could tell a sociological story about the professionalization of legal history and the production of more legal historians. I think the interesting way to tell that story, or part of that story, is as the result of a faltering of this common law version of history. Why did that happen? Well, I think the main two forces were movements in the 20th century, theoretical movements and practical movements, legal realism, and I think maybe especially something called critical legal studies. Now, the latter it was a movement of roughly the 1970s and 1980s, almost completely forgotten now. But I think along with a few other traditions, famous tradition associated with J. Willard Hurst, helped bring about the current exciting era of burgeoning legal history. Why did that happen? Or what were the principles of these movements that have created that excitement? It's worth noting the importance of critical legal studies in passing. Two of really the leading legal historians of the past generation, who have many, many students and disciples, Morton Horwitz and Robert Gordon, were both originally partisans of this movement. So I want to suggest that the best way to characterize what was interesting about legal realism and critical legal studies is their insistence that traditional legal forms of historical consciousness were insufficiently historical. On the view that they championed, we can't understand the path the law takes, including the interpretations of the law that judges make at any point, through the workings of internal interpretive practices. There were also big external factors that may have been more important, things like politics and ideology. Now, I think the force of this claim, and that's kind of summarizing a huge number of people in very different movements, but still, the force of the claim was to make the idea that law evolves through internal interpretive practices unbelievable. And I don't think anyone really believes it anymore. If you like, our historical consciousness has evolved beyond its intralegal origins and now operates on its own, outside of the internal self-interpretation of law, in order to understand it better. So let me close with a couple of points. The first is that internalism dies hard. I mean, these are millennial practices. Of course, they're alive and well in Judaism, but to come to the common law, it's also, I think, alive and well. There's a famous historian of English law named Frederick Maitland, who once claimed that the forms of action haunt us from the grave. And I basically think he could have said the same thing today about the common law in general. Let me give some examples of what I mean. Consider the two most famous normative proposals to reground American law in our time. I think if you were to choose two, the first would be Richard Posner's invention of law and economics, which says basically that law should promote allocational efficiency. And then take Ronald Dworkin's view, his very philosophical jurisprudence, which says that law should promote liberal values. Now, amazingly, in the 1970s and 80s, when these guys were championing these views in the legal academy, both were compelled to insist that they weren't just making up these theories and imposing them on the law. They were driven to claim that they had always been there, that they were the fruit of the slow evolution of the common law and were to be found in important cases, say. So in the famous example of Richard Posner, he says, in the 19th century, the law of negligence actually was operated according to principles of allocational efficiency. Now, I think no one believed them at the time. Everyone saw that they were imposing external views of what the law ought to be on their readings of the common law. But I think this really suggested, in a sense, how much the historical consciousness of the common law still lasted until surprisingly recently. I think today everyone's version of what the law ought to be stems from external factors, and most people know this or would admit this, whether they have some ambitious external theory such as Dworkin's or Posner's. But still, very often, they're tempted to claim that their views already have a foothold in the evolution of the law and can be kind of extrapolated from there. Now, it's against all this that I think the historical views I talked about, the second act in which history moves outside the law, seems exciting and seems worth pursuing. Now, of course, legal history that looks at legal life, legal actors, legal interpreters from the outside has to take seriously the beliefs of past actors. So if we were to study Jewish legal interpretation, we would have to understand their self-interpretation. And the same would be true of common lawyers. In fact, we're able to make analogies between them in part because we're outside both traditions. They wouldn't have been able to see how proximate, perhaps, they really were in the ways they interpreted the past and tried to bring it into the present. But the fact that past actors are working inside closed legal systems and their self-understanding is really important doesn't mean they have the authority to tell us why they made the choices they did. Instead, it seems as if we do have to look to external factors, politics, ideology, social change. They may have believed that their changes in the law were driven just by interpretation from the inside, but those external factors seem to be working their force on them nonetheless. So history should approach law, and it should on the premise that there's a line at which, history can approach law on the premise that there's some line at which society ends and law begins. Instead, law is just a feature of society and has to be understood as part of society, culture, and politics. And it seems to me that this is a real breakthrough in relation to the whole history of historical consciousness. And it seems to me it's one we should cherish and continue working out.
Thank you very much, Sam. And I'm going to now ask Professor Assaf Lovsky to address us.
Okay, so I'm really glad that Sam started because he gave you a very broad brush description of the relationship of law and history from an historian's perspective. And I'm going to tell you a story about legal historians, the way I see the historiography of legal history, the way legal history developed. And I'm not going to go back to the medieval Judaism or early modern Judaism. I'm going to start in 19th century, talking about legal historians in the 19th century and in 20th century, and then talk a bit about the way I think Jewish studies, not Judaism is practiced, but the way academics studied and are studying Jewish law evolved in the 20th century. So basically what I want to do is talk a bit about the description of this panel, doing two things. First, say a few words about the external and internal, contextual and formalist understanding of law that the description talks about from the perspective of legal historians. And then, since the panel is sponsored by the Center for Jewish Law, I'd like to talk about the external and internal approaches to the study of law as used by academics interested in the study of Jewish law in the 20th century. Actually, I'm going to talk about one specific person, a forgotten forefather of people doing studying Jewish law academically, who was one of my favorite Jewish law scholars of the early 20th century. Okay, so the starting point of my comments is the observation that was made in the description of this panel, which talks about recent methodological shifts within both the historical and legal communities. A historian, says the description, used to view law from an outsider's perspective, seeing legal norms as a reflection of non-legal context, whether it's economic, social, or political. And legal scholars used to see law, as we just heard, as an autonomous entity with its own distinct language and logic, one that should be understood from within. And in recent years, lawyers and historians came to realize that both views of law are misleading. Historians no longer see law as merely a reflection of non-legal context, paying more attention to the way lawyers and judges actually use and view law. And legal scholars now realize that external historical context is essential for understanding legal text. And this is the description of the panel also says this is something that Jewish studies is now being influenced by. And in many ways, this description is kind of the conventional story that legal historians tell themselves. There's a shrinking distance between the external and internal, the contextualist and the formalist or autonomous perspectives on the study of law. And specifically, if we look at legal historians, we see that the intersection between law and history has really kind of shifted. One might say that legal history between the 1950s, say, and now witnessed a shift from a more functionalist and instrumental understanding of the relationship of law and its outside context, a historical view, to an understanding of legal history, which was inspired mainly by critical legal studies mentioned by Professor Moyn, which I think emphasizes not so much the social history of law, but the intellectual history of legal doctrine. There's a rise of, within legal history, there was a rise of interest in neo-doctrinal histories of law, which is a result of a jurisprudential change, the rise of critical legal studies in the 1970s and 1980s. This may have also been at least partly influenced by the general shift in historiography and the way people are doing history since the 1970s and 1980s, a move from social and economic history to a new kind of intellectual and cultural history, one focused on studying language and representation rather than social, political, or economic facts. And now, kind of when one reads this description, one has a tendency, at least as a historian, to think whether this description is accurate, both going to the present and moving backward to the past. So I think if we look at what happened before and after the 1950s, the period between the 1950s and 1980s, one might come up with a different picture of the relationship of external and internal histories of law. So first of all, let me begin actually with the present. It's quite difficult to say where legal history is right now. We obviously lack the required perspective. And so we really can't say what the dominant approach of legal historians is now. But if I can try to guess, I think certainly neo-doctrinal interest in legal history, one which is based on a more autonomous notion of the nature of law, has really waned since the 1980s. This is no longer dominant. But it doesn't mean that we went back to the approaches that Professor Moyn talked about, which were, I think, mainly inspired by legal realism, which are more contextual, functionalist, evolutionary. I think what is happening actually now is that instead of asking questions about the relationship of law and society, whether we see law as related and influenced and reflective of society, or whether we think law is autonomous, in a sense the debate has moved sideways, and now what people are really interested is questioning the very notion of what society is. So I think the thing that is really most exciting now in the work that is being done by younger legal historians is actually to question whether there's a single society that we can talk about when we're studying law. Many legal historians are now doing comparative transnational or international legal history, which transcends the boundaries of any given society, which of course I think is great news for people interested in Jewish law, because Jewish law is a legal system that is not related to a single society and certainly not to a single state. It's a legal system that has functioned in many social contexts, in many societies, and in many periods. It's one of the great examples of a legal system which is in many senses transnational. Okay, so if you look at the present, the question I think for legal historians is no longer whether law is reflective of society or politics or economics, or whether law and legal discourse are autonomous in any way. The question of law and society is no longer the major question, because society, it no longer exists as a single entity rather than a society which we're studying. We are not seeing societies as related to each other, and therefore the legal system is also related to each other. So this is kind of an observation about the present state of legal history. But actually I want to go back to the past, where I feel more certain and more confident I know what happened before the 1950s, and I want to talk a bit about the period 19th century and the early 20th century, and talk about how the nature of legal and historical scholarship during this period. So while the external and internal functionalist and formalist approaches to the study of law were indeed in a sense segregated in the 1950s and 1960s, historians using an external approach to the study of law and lawyers using an internal one, that was not always the case. And if we go back in history, we find the two approaches, the external and internal, often mixed together in the work of historians and lawyers. And the examples I like to give are taken from the history of 19th century legal thought. So if we examine European legal thought in the 19th century, at first glance, it seems possible to talk about couples of thinkers which are segregated or separated, each one representing one of the two competing perspectives to the study of law that we previously mentioned, the external and internal. For example, if we look at the first 3 decades of the 19th century, one might compare people like Friedrich Karl von Savigny, a German legal scholar, one of the founders of the German Historical School, a very influential academic school of study of law, and compare him to people like John Austin, one of the founders of English jurisprudence. Okay, so Savigny and the German Historical School viewed law as a reflection of outside culture. In their case, they talked about the Volksgeist, the spirit, national spirit. So law was, in a sense, marginal to what really was interesting for them, which was to study the history of the cultures of given societies. And people like John Austin, who was a follower of Jeremy Bentham, viewed law as independent of society, legal norms being defined, according to Austin, by a formal criterion. He talked about law as being the command of the sovereign, a criterion which was not related in any way to non-legal factors, whether it was morality, politics, economics, culture. And one can think about similar couples in the intellectual history of European legal thought. For example, if you think about the mid or late 19th century, one might compare people like Henry Maine, an English comparative historian and legal thinker, to the formalist creators of the English textbook tradition, people like William Anson or Frederick Pollock. However, on second glance, it seems that both the external and internal views of law often existed simultaneously in the work of individual legal thinkers. For example, if we talk about Savigny's views of law, we find that he did identify law at certain stages of its development with custom, seeing it as a bottom-up, unconscious reflection of the national spirit of a given people. But in his historical description of the development of law, which was mainly based on the history of law in ancient Rome, he also argued that law was, at certain stages of its development, a product of a scholarly professional elite, and was thus autonomous of society. And indeed, the legal methodology that Savigny and his followers created, the historical dogmatic approach, was based on a combination of external and internal approaches. The legal scholar was supposed to turn to history to find in it the raw legal facts, assuming at this stage that law was embedded in the context of a given society, and then at the second dogmatic stage or doctrinal stage, to systematize these facts, creating a coherent, decontextualized, and autonomous legal system. Crossing the Atlantic and moving to American legal thought, we find the same phenomenon. Ever since Roscoe Pound, the famous American legal thinker and sociologist, we tend to view late 19th century American legal thought as a formalist, disembodied, decontextual enterprise. However, in recent years, a growing body of revisionist literature has questioned this conventional view. People like Stephen Siegel, David Urban, Kunal Parker have argued that contrary to the conventional account, late 19th century American legal scholars did not view law in an autonomous, formalist, non-contextual way. Instead, history played a major role in the work of some of the leading American legal scholars of the late 19th century. There was, according at least to David Urban, an Anglo-American historical school, just like Savigny's German historical school, which combined an interest in history with an interest in the study of doctrine. 19th century American legal thinkers, Ames, Bigelow, Carter, Oliver Wendell Holmes,
according to Rabban, used history as their central methodology in the study of law and viewed law and history and society and politics not as two separate entities that should be studied independently by different subdisciplines, but as one unitary whole fused together by an underlying evolutionary framework. It was only in the 20th century that history and law separated. Law schools focusing on internal doctrinal studies of law, devoid of any notion of history and change, and historians adopting a view of law that saw law as totally dependent on social and economic forces. So actually what I'm arguing is that it's indeed true that law and history as academic disciplines were segregated, but they were segregated in American legal thought only in the 20th century, and before that they were actually fused, as they were in European legal thought. And I want to use this actually as an introduction to, because actually I'm more interested in talking about Jewish law scholarship. And the question is, what happened in the study of Jewish law, in the academic study of Jewish law? It's not surprising to discover that because of the 19th century German influence, the same mixture of non-contextual and contextual approaches also existed, at least before the mid-20th century, in the academic study of Jewish law, something that emerged as Judaism became secular in the 19th century. The example I would like to give to illustrate this point is taken from the history of Jewish studies at the Hebrew University, which is, as Suzanne said, I'm interested in the history of mandatory Palestine, and the Hebrew University is a major institution in the intellectual history of mandatory Palestine. So I'd like to talk about the Hebrew University in the early decade of the 20th century, when Jewish law was one of the first subjects that was studied there. It was studied as part of the Institute for Jewish Studies that was established at this university. And the first Jewish law scholar, again, one of our forefathers, at least people who are interested in Jewish law in its intellectual history, the first scholar of Jewish law in Palestine was a person called Asher Gulak. So Gulak is a really interesting person. He was born in Russia, studied at the University of what is now called Tartu in Estonia. He was one of the founders of something called the Hebrew Law Society, an academic society established in Moscow during the Russian Revolution, devoted to a political project, the project of the revival of Jewish law. And obviously, once the Russian Revolution progressed, people interested in Jewish law and its revival could no longer function in the Soviet Union. So in 1925, he immigrated to Palestine and joined the Hebrew University, where he taught until his death in 1940s. Throughout his life, Gulak used the German-inspired historical dogmatic method created by 19th century German legal science to study the history of Jewish law and the content of Jewish law. However, there was a discernible shift in the specific scholarly methodology Gulak used before and after his immigration to Palestine. As a young scholar in Europe, Gulak studied Jewish law using the dogmatic approach, seeking to systematize Jewish law and to discover its non-temporal, fundamental, timeless principles in order to organize its norms using the categories of Romano-German civil law and in order to codify it. The systemization project was seen as a preliminary step toward the codification of Jewish law, which was itself a preliminary step towards its revival. Gulak's work at this stage, the European stage, was summarized in a 4-volume book, a really impressive book written in Hebrew and entitled Yesodei HaMishpat HaIvri, Principles of Jewish Law, which was published in Berlin in 1922. When Gulak moved to Palestine in 1925, his methodology changed. Instead of attempting to distill the timeless principles of Jewish law and then organize Jewish law using Roman law-inspired categorization schemes, Gulak now began studying Jewish law using a comparative historical approach. The new methodology was evident in a book published in Jerusalem in 1935, 5 years before his death. This book, curiously enough, was written in German, and the English translation is Legal Documents in the Talmud in Light of Greek Papyri from Egypt and Greek and Roman Law. The difference between these two books epitomizes, I believe, the transformation that Gulak underwent when he moved to Europe, from Europe to Palestine, a transformation in which the physical change of place was accompanied by a scholarly change of methodology. יסודי המשפט העברי was published in Berlin, but the book was written in Hebrew and intended for an audience which was Jewish. It was not merely an academic work, it was meant to organize Jewish civil law in order to contribute to the process of Jewish legal revival. Gulak's 1935 book was published in Jerusalem. Ironically, however, it was written in German, not in Hebrew, and that's 2 years after Hitler's rise to power. And the question that this book sought to answer was what was the scope of the influence of Greek and Roman law on the Talmud, a question that had little to do with the contemporary project of reviving Jewish law. It was purely a historical work. So Gershon Scholem once wrote a book, a memoir called From Berlin to Jerusalem, which tells the story of his physical and intellectual move, Scholem's physical and intellectual move from Germany and an immersion in German culture to Palestine and to a commitment to the project of Jewish studies as a Zionist project, actually. And Gulick, in some senses, also moved from Berlin to Jerusalem. But his move was far more complex. When he lived in Europe, he was a nationalist legal scholar committed to the revival of Jewish law, publishing his work in Hebrew and studying law, as I said, in a non-contextual and autonomous way, or assuming that law was an autonomous entity. When he moved to Palestine, he became a detached historian, writing in German and using a comparative historical method to ask non-practical questions about the history of Jewish law. So how does one explain Gulak's confusing move? The explanation may have simply been personal. Again, this is maybe parallel to some things that Professor Moyn was talking about. Gulak became an expert papyrologist and acquired knowledge of Greek only after he immigrated to Palestine. This, however, does not explain the use of German, for example, instead of Hebrew in his 1935 book published in Jerusalem, of all places. An alternative explanation can be found in the institutional culture of the Hebrew University. During the Mandate, the Hebrew University was conceived in Europe by cultural Zionists, people committed to Jewish cultural revival, but the university actually established in Palestine was dominated by assimilated German Jews. Some of the Jews were not Zionists, and those who were did not share the enthusiasm of their East European colleagues for cultural, linguistic, or legal revival of Jewish culture. Instead, they were bent on proving their academic worthiness to the Western academic community. Gulak was required by his colleagues, either implicitly or explicitly, to publish works which would be accessible to the international community of comparative legal historians, whose main research language, or one of the main research languages at the time, was German. And Gulak therefore adjusted his research agenda to meet the demands of the university. Whatever the factors that changed Gulak's scholarships were, I think the story is interesting because it illustrates the complex interaction between the external and internal study of law and shows how once we examine the thought of specific scholars, the two are often intertwined. Another interesting lesson that Gulak's story, I think, holds is that the external and internal perspectives on the study of law and history are often related to bigger interests and goals. In Gulak's case, the internal formalist approach to the study of Jewish law was related to the Zionist project of Jewish cultural revival, and the external historical approach was related to the institutional interests of the young Hebrew University, seeking academic legitimation abroad. Whether similar interests are involved in the way Jewish law is studied today in Israel or indeed here in New York is something that I think is really fascinating and interesting. I really don't know. I hope Suzanne will talk a bit about why Jewish law is interesting for people who are studying it in New York, and that is something I think we should leave for the discussion.
Thank you, Assaf. So our next speaker is Professor Richard Ross.
The conference prospectus describes and celebrates a cross-fertilization of law and history that it argues has been achieved in recent years. Once, historians treated law as the product of socioeconomic forces, while lawyers regarded it as a normative practice with its own internal integrity. But of late, goes on the prospectus, there has been a convergence in the working assumption of the disciplines of law and history. The prospectus praises legal study for being more attentive to historical change and social context, and praises historical study for becoming more conscious of law's internal processes of thought. On this account, legal theory has been a critical force encouraging convergence and cross-fertilization. So in reaction to this, I want to do three things today. First, although I accept there's been a partial convergence, I want to question whether legal theory played as prominent a role in this convergence as the prospectus claims. So I'm going to begin by being a bit contrarian. Secondly, the prospectus asks how this law and history convergence can enrich Jewish studies, and I'm going to interpret this question broadly and look at the study of religious legal traditions, which will include Christianity as well as Judaism. And I'm going to temporarily resist the charms of historicized law and legally conscious history, because I want to discuss how belief in the divine foundations of a religious legal tradition creates special problems when trying to historicize and contextualize that tradition. And finally, third, enough contrarianism, I'll get with the program and identify a few places where legal theory can further the law-history convergence with respect to religious legal traditions. Okay, so to begin, what caused this law-history convergence? Perhaps the key contribution of legal theory has been the concept of legal culture. This arose in the 1960s as an analog to political culture. It was a concept that tried to fuse institutions, rules, values, and social context into one unified notion, a way to capture the flavor or style of a legal system. And as you see, it self-consciously brought together the internal ideas of a legal system with wider socioeconomic context. But I think that this aside, scholarly developments outside of legal theory account for far more of the law history convergence. And here are a few reminders. By the 1960s and 70s, internalist study was under pressure in many fields, in history of law, in history of religion, history of science, and so forth. One strategy was to work towards an externalist stance and emphasize the degree to which law or religion or science developed in reaction to socioeconomic and political contexts. The conference prospectus describes historians' treatment of law in this fashion. But another response was to question the dichotomy between ideas and context. One might consider in this light the social history of ideas, or histories of the reception of ideas that asked which experiences help make ideas persuasive. More radically, some historians question to what extent ideas and larger socioeconomic and political contexts, let's call that reality, could be distinguished at all. The argument went like this: people apprehend and understand reality through the intermediation of intellectual concepts. On this view, reality does not stand outside of ideas, some sort of independent variable that shapes ideas. Rather, it is intrinsically bound with ideas because reality can only be described through ideas. Whatever one thinks of this theory or its more extreme formulations, the point is that attempts to achieve convergence or cross-fertilization between context and ideas was very much on the agenda for decades, quite aside from legal theory. Closer to home, for lawyers and legal historians, was the work proliferating since the 1960s and 70s on Anglo-American constitutional and political thought. Lawyers and legal historians were drawn to this work because of the great importance to them of the formation of the federal and state constitutions in the late 18th century. It was essential to establish the historical background to these events. And so lawyers and historians read the work of people like Edmund Morgan, Bernard Balin, Gordon Wood, Jack Green. Despite all their differences, all of these scholars stressed the way that political and constitutional discourses emerged out of particular institutional and socioeconomic contexts. They also stressed how these political and constitutional ideas organized experience for early modern Englishmen and colonists. These ideas suggested ways to interpret an uncertain and contradictory reality. So from the 1960s forward, these historians were modeling the convergence that this prospectus speaks of. So thus the case perhaps for the lesser importance of legal theory. Let me now move to the second major thing I'd like to do in the talk. So the convergence between law and history has arrived, and the prospectus is optimistic that the cross-fertilization that comes from this convergence can enrich Jewish studies, or more broadly, the study of religious legal traditions. But I think there's reason to be, if not pessimistic, at least cautious about this claim. A problem arises if you try to historicize and contextualize the study of a religious legal tradition if you believe in the divine foundations of the tradition. To say that religious legal traditions arose on account of external social contexts plus internal modes of thought presents no difficulty to a scholar if you are not a believer in that religious tradition. It also presents no difficulty to a scholar of a secular legal tradition. But suppose you assume that the core precepts of a religious legal tradition came, such as Judaism, came from the mouth of God at Sinai and bind Jews all over the world for all time. This perspective can certainly be squared with at least a partial historicization of an evolving religious legal tradition. One thinks of Maimonides, or one thinks of the scholars referenced by Sam, who charted how medieval and early modern Jews understood themselves to be different than pre-exilic Jews. But a full and thoroughgoing historicization is difficult. The limit on historicization and contextualization arises if one believes that the precepts revealed at Sinai are divine and continue to bind today. This is a problem not only for Jews, but also for Christians who take the moral law and Christ's word to be divine, eternal, and universal. Let me illustrate this point with an example from early modern history. In late 16th and early 17th century England, Scotland, and part of Germany, a group of Calvinist Protestants sifted through Old Testament judicial law in order to separate superseded ordinances particular to the ancient Jews from the eternally valid precepts that still bound contemporary Christians. Here's how they were different from the majority of their fellow Protestants. All Protestants agreed that the moral law continued to bind contemporary Christians. All agreed that the Jews' ceremonial or ritual law had been superseded by the arrival of Jesus. The dispute among Protestants was over the status of the judicial law of the Old Testament, over matters like contract law, inheritance, procedure, crime, so on and so forth. Most Protestants believed that Jesus' arrival had abrogated the judicial law. But this minority, who I'll call Mosaic legalists, believed that the judicial law still bound contemporary Christians under certain circumstances. If the judicial law was touched with the natural law, or upheld the Decalogue, or upheld the family, commonwealth, and the church. This project of arguing for the continued validity of revealed judicial law put the Mosaic legalists in conflict with other Christians who were most busy trying to contextualize and historicize the Jewish tradition, namely the Christian Hebraicists of the early modern period. The Christian Hebraist scholarship told of the reconfiguration of Jewish laws and institutions as Moses and Joshua gave way to the judges, the kings, the Babylonian, Hasmonean, and Roman periods. The Christian Hebraicists argued that the institution of the synagogue emerged and worship rituals changed between the First and Second Temple periods. They argued that where the ancient Israelites had been a self-sufficient and culturally insular people devoted to agriculture and husbandry, their descendants in the centuries before Jesus uneasily opened up to commerce and Hellenistic influence at some cost in economic equality, spiritual standards, and public-minded virtue. So against this dynamic background, so they're trying to portray Jewish history as dynamic in the manner of Roman or Greek or Egyptian history. Against this dynamic background, the Christian Hebraicists enjoyed showing how Jews reinterpreted or abandoned Old Testament precepts, focusing on the Jubilee, divorce, and on and on and on. The Mosaic legalists had very little interest and indeed tried to suppress internally these detailed periodizations of the Jewish past established by the Christian Hebraists. Nor did they heed their contemporaries' proliferating doubts about whether the Old Testament provided an accurate account of Jewish history and God's law. They shied away from asking whether the scriptural text had been corrupted by the Jews during a long period of redaction. The reason for the Mosaic legalist resistance is that they were trying to build a bridge from ancient Israel's judicial law to the early modern Protestant lands. Precepts traveled across this bridge to bind contemporary Christians. And the bridge can be threatened in a number of ways. An overly historicized and overly contextualized account of the Israelite past or the emergence of scriptural text could make the ground under the pylons of this bridge irregular and shifting. Now, to be sure, the 17th century Mosaic legalists were clumsy by the standards of modern scholars of religious legal traditions who labor to reconcile divine revelation of eternal truths with the historical development of precepts. My point in discussing the Mosaic legalists is to suggest that no matter how ingenious the reconciliations, at some point, commitment to the continuing validity of divinely revealed precepts presents a barrier to full historicization and contextualization of religious legal traditions. There has to be this bridge that connects divine revelation to the present so that obedience to precepts is obligatory. You can build the bridge in a lot of ways, and certainly better than the Mosaic legalists did. But full contextualization and full historicization eats away at the bridge. And this ultimately makes religious legal traditions different in essence from the common law, civil law, or secular legal traditions, which is one of my reasons for skepticism about the call in the prospectus. Okay, let me turn to the third part of the talk, and I'm going to do what I ask my kids to do, which is for once leave their contrarian phase. And I'm going to get with the program now and consider how legal theory can advance the law history convergence and enrich the study of religious legal traditions. So you can't talk about legal theory in the abstract, so let me pick one piece of legal theory, H.L.A. Hart's notion of the rule of recognition. To get started, let me distinguish two biases in trying to integrate law and history, what I'm going to term the horizontal and the vertical biases. And these are biases because no one ever practices fully in one mode or the other. Start with the vertical bias in the study of law and history. Here your bias is to link up a historical actor or event to the present. So consider Roger Williams. We'll stick with religion. Roger Williams, that brave and odd and cranky and annoying founder of the Rhode Island colony, who is too easily celebrated as a champion of modern religious toleration. Working in the vertical mode, one might connect Roger Williams to religious toleration in the present. Perhaps the link is genealogical, we are inheritors of Williams' ideas, or maybe the link is about legitimation. Religious toleration can be enthusiastically defended today because it was there in our earlier settlements. Parenthesis, well, maybe if we ignore Williams' searing contempt for humanity and his contempt for everyone else's false faith. Or perhaps Williams can be treated as a font of first principles to be used in judging or denouncing present compromises. But the ultimate objective of the vertical mode is this. Legal history can be used to illuminate the buried assumptions of the present day, or it could give guidance and courage to present-day disputants, or it can reveal unconsidered alternatives. Then we might distinguish the horizontal bias. Here we want to link up the actor or event to its contemporary contexts. So back to Roger Williams. Working in the horizontal mode, we could connect Williams to the 17th century Dutch policy of connivance, where the Dutch said they had an established church, but they connived at and therefore de facto allowed other religious beliefs. You could connect him to the French politique case for de facto toleration. Horizontal bias establishes a contextualization. It allows you to have a richer appreciation of the historical actor or event. This way you can better understand how the object of study was typical or innovative. You can better reveal the meaning and implications of the actor's thoughts and choices. The ultimate objective is to understand a society in its own terms. Okay. The claim I want to make now is that legal theory can help enrich the law-history convergence as practiced in both the horizontal and the vertical modes. So let's consider Hart's rule of recognition. The English, mid-20th century English professor H.L.A. Hart holds that legal systems employ an underlying rule of recognition that identify what precepts count as law within a system. To say that a rule is valid is to mean that it passes the tests provided by the rule of recognition within that particular system. Okay, so back to religious legal traditions. Both Jewish and Christian legal theory present particularly tricky rule of recognition problems because they recognize the continuing validity of at least some divine scriptural precepts. I'm going to leave to the side for a moment how these traditions deal with purely civil laws with no connection back to Scripture. But precepts emanating from Scripture can be divided into at least three classes. One class are the supposedly eternal and universal scriptural precepts. A second are precepts that Thomas Aquinas would have called conclusions, which are deductions of more specific secondary and tertiary principles from foundational divine principles. And third, we have what the Thomists would have called determinations. These are civil ordinances that apply divine injunctions to specific cases. They operationalize them. So to give an example, where Scripture prohibits an act, civil law would have to determine the punishments and the modes of proof and procedure. Well, with this scheme in mind, it's apparent that Judaism and Christianity each generate multiple rules of recognition. First, you need rules to show believers which precepts of Scripture are still binding. So Christians, for instance, would distinguish between the moral, judicial, and ceremonial precepts of the Old Testament. Jews would distinguish between precepts valid in exile and precepts valid in the Holy Land, and so on and so forth. Secondly, both Jews and Christians needed to create rules of recognition to differentiate purely civil rules from these determinations and conclusions, and to decide which purported precepts in all of these categories were valid and true. Now, this overall tripartite structure with all these rules of recognition is not peculiar to religious legal traditions. Natural law had it too. So again, in the Thomist system, you have the primary natural law precepts, then you have determinations and conclusions. Okay, so what's the upside of bringing in this legal theory idea, the rule of recognition? Well, working in the horizontal mode and looking to contextualize the phenomena under study, one sees that religious legal traditions with very different substantive rules can share similar rules of recognition. The Jewish and Christian legal traditions, and possibly Islam as well, though I don't know enough to say, the Jewish and legal traditions share with natural law this problem of accommodating divine eternal principles with the mutability of human affairs. The particular role that rules of recognition play within these religious legal traditions suggests a way to treat them comparatively. The operation of rules of recognition in religious legal traditions reveals structural similarities otherwise obscured by differences in those religious traditions, institutions, and substantive laws of conduct. Using the legal theoretical idea of rules of recognition, then, provides a valuable tool for a comparative history of religious legal traditions. If we switch from the horizontal mode to the vertical mode, we see that a study of rules of recognition in religious legal traditions could provide further examples or data for jurisprudence working out the meaning and implication of the notion of rules of recognition. The vertical mode, after all, seeks to use historical and contextual studies of legal traditions to enrich legal theoretical categories in the present. Let me conclude, a bit playfully, by treating the conference prospectus itself as a bit of legal theory. So it advances a program that Jewish studies and religious legal traditions can be enriched by historicizing and contextualizing law and doing history aware of the internal logic of law. Well, this is, of course, not the first time such moves have been proposed. Well, not exactly in the same way, but there's a family resemblance in the past. So consider in 16th and 17th century Europe the scholarly agenda proposed by legal humanists, drawing upon the expertise of antiquarian studies. Legal humanists working in the French tradition treated Roman law not only as a transcultural written reason, but also as a set of reactions to shifting challenges created by Roman society at various points in time. And they did similar types of moves on religious traditions as well. Another example might be 19th century critical approaches to scripture. Now, legal theoreticians seem to delight in playing tricks on historians. So since I have on my historian's hat for now, instead of my lawyer's hat, I can do a historian's trick on theoreticians. So the prospectus for today's conference echoes calls made in the past, in various centuries in the past. And if we jump the gun and see today's prospectus as already a historical document, it can be fitted into a particular history, namely the history of ambitions to historicize.
Thanks, Richard. We did meet at a history workshop, didn't we?
We did, yes.
Thank you. I'm going to call on Professor Shai Lavi to sum us all up and put us on the straight and narrow.
Good evening. Thank you, Suzanne, for inviting me, and thank you for the previous speakers. There's a disadvantage in speaking last. You're all tired. You've heard almost all that you can bear. I was fascinated by the lectures. There's an advantage of speaking last. The advantage is that I can build on some of the things that were said and also perhaps be a little bit critical on the sides. I get the last word at least going last. So I want to address the core question, this tension between internal perspectives and external perspectives, law and the internal understanding of law, and history as an external perspective about law. And I want to suggest, as a starter, that although history is unique in some ways, it's more important, perhaps, to understand that this problem arises not just from the intersection of history and law, but of other disciplines, anthropology, sociology, economy. And so we see the same problem. I studied at Tel Aviv University in the early 90s, and at that time there was no law and. Most people were doing pretty much disciplinary, doctrinal, internal perspective of law. When I came back 6 or 7 years later, everybody was doing law and. Nobody was doing law anymore. It was out of fashion. Everybody was doing law and we're using the methods and theories of other disciplines to decipher what was going on in legal materials and in the study of law. I thought at the time that law could be likened to a dying to a person who has donated its body to science. Right? There are the corpses lying. All doctors from all kinds of different disciplines are coming to dissect the body, which is still warm but has nothing to say back. So my question for this evening is, what would law, if it were suddenly to resurrect itself, what could it possibly say back to the sciences of law? And it's important for me to suggest that, so I'm turning the tables on law but it's important for me to emphasize that my aim is not to defend legal autonomy at the price of at the price of confining it to the secluded wards of legal formalism or positivism. The latter, the internal sciences of law, I'd like to suggest, share much more in common with law and scholarship than may seem at first. So, with an analogy to Jewish law in the background, right, the way to go about this is not necessarily to adopt the critical studies of law that would kind of ruin the bridge or destroy the bridge to revelation, nor is it to adopt an orthodox position that kind of looks at law only from an internal perspective, positivist or formalist in legal studies. So So I'm not looking for an in-between solution either, trying to kind of compromise between internal perspective and external perspectives. Rather, what I'd like to suggest is a turn to jurisprudence as an alternative to both, and I'll explain in a minute how that could work, and coin the method that I'm suggesting, perhaps jurisprudential history, because history will play an important role in this. So when we think about jurisprudence, the central question, the fundamental question is, what is law? Now, the difference between the sciences of law, both internal and external, and the jurisprudential understanding of law, is that the sciences assume, before they start working, they assume, sometimes explicitly, mostly implicitly, an answer to the question, what is law? That's what turns them into a science. So when we talk about internal sciences of law, positivism and formalism as examples, that's clear. Positivism assumes that all law is positive law, and formalism assumes that all law is a question of the form of law. And let me just say a little bit for people who are not familiar with these stories, with these theories. Positive law, for example, says that all law, to give a simple definition, is posited law that is a result of the will of the sovereign, supported by a sanction. And so the problem is that the sciences of law, internal and external alike, assume an answer to the question, what is law? Now, it's easy to see why this is the case with positivism and formalism, but I'll say in a minute why this is true also about the external perspectives on law to a large extent. Now, now this clouds our vision of the legal phenomena, because we presuppose an answer to the question. Let me give an example from Jewish law, which is not my specialty, but it's a good example. It's based on David Dowby's study of ancient law, and specifically of Jewish law. And he has something interesting to say about the Ten Commandments and about the mitzvot in general. He asks, what is the jurisprudence underlying the mitzvot? Now, we expect an answer, one possible answer, one common answer is that they're commandments. Hence, we think about them in similar lines to positive law. That is, they're divine commands, and there's a sanction that often follows if you disobey the law. Now, the sanction can be different from what we understand. Obviously, the commander is different from a secular commander, but the jurisprudence is similar. David Dowby points to the fact that, in fact, the mitzvot are not commandments. As a grammatical form, and this is something we can talk about, we won't have time now, but as a grammatical form, the mitzvot are not formulated as a commandment, with very few exceptions, if any. So it's, to return to Zachor, the Yerushalmi book, that's a commandment, Zachor, but that's a mitzvah, but it's not a commandment. The commandment would be in Hebrew, Zachor. Many of the mitzvot, possibly all of them, are actually not framed in the grammatical formulation of a commandment. And so this suggests a different understanding, a different jurisprudential understanding of what law is. Dowby has this answer to what, for a different jurisprudence that would arise out of Jewish law for what the commandments could be. There's no punishment in the Ten Commandments for what happens if you don't obey the law. This is another divergence from positive law. So it opens our minds to asking this question. Now, it's easy to show this with internal perspectives, that is, that giving a presupposing an answer limits our understanding of historical phenomena, but it's also true when you go to the external disciplines. And mine, in training, is sociology. So sociologists assume, on one level or another, that all law is social. To quote Professor Moyn, he said that law is a result of politics, ideology, and social change, for example. So the assumption is that there's this interconnection between law and society. And Professor Lovsky said correctly that if we want to go beyond this law and, we need to rethink what we mean by society. That is, we need to understand that identifying law with the social, as sociologists do, is only one possible answer, a very modern answer, to the question, what is law? So some scholars have already pointed out that the concept of the social is actually a very modern answer to the question of how do we belong together. Society is only one formation of being together with other people. And there are other ways of being together with other people, and sociologists are somewhat blind to this fact due to their disciplinary presuppositions. They don't have to be, but it often happens to be the case that they are. So let me give an example of this and how asking questions of jurisprudence when you approach historical texts could be helpful. I want to refer to a book by Marion Constable, The Law of the Other, and she tells a very interesting story in that book. She talks about juries, the history of a specific phenomena, the mixed jury, which has its origins in the Middle Ages, in the late Middle Ages, or maybe before then. And one of the examples that she uses, historical examples, is what happens to a Jew when he's tried in a court, sort of a non-Jewish court, a Christian court. And the practice was to have a mixed jury. That is, a jury that would be comprised half of Jews and half of non-Jews or Christians. And this was the case also with other instances, not only with Jews, also with certain professions, that people would be judged according to their own law. Now, what this example suggests, and I think this may be somewhat intuitive to people in the audience, is that the modern conception is that somehow social factors construct law, right? But this history, and also Jewish history, suggests that it's not society that constructs law, but rather that law gives an answer to the question of how we belong, of how people could belong together to each other. And in her book, and this is very brief and not very concise, but in her book, she juxtaposes, contrasts this medieval understanding of law and the answer that it gives to how people belong to each other with the modern notion of the jury. When we say today, when we talk today about the jury, we think today in concepts of society, and we'd like the jury to represent society, by which we mean the population understood through statistics, which is a very different understanding of how we belong together. And then we talk about how the jury needs to be a cross-selection of society, and we think about and the law, and we don't have this thick understanding of how the law that one is judged by is one's own law and says how we belong together. So this would be a different understanding of society, and a similar move could be an understanding other factors of law and other jurisprudence of law. So this was only one example. So I want to conclude, and I know I'm probably brief, but as I said, it's late. I want to conclude by just emphasizing the morals of this kind of move. One of the morals is that law can teach them something, jurisprudential history can teach something to the other disciplines. That is, it can show the other disciplines their limits and their presuppositions. And so this study of law turns the tables on law, and in this sense. The other concerns Jewish law, and which is a sub-theme of our discussion, and asks why is Jewish law so important. And I think that at least the Constable example, which I spoke about briefly, alludes to the fact that when we look at Jewish history, because Jews historically were constituted by their law, I think one could say that there's a historical sensitivity to what happens to this law and to the transformations of this law and the transformations of how people understand their belonging together, so that we have both the importance of historical jurisprudence or jurisprudential history and the importance of studying Jewish law. Thank you.
So I'm very anxious to turn this over to everyone for questions. I have a load of them too, but I think I'll let everyone else first speak, and then if I need to fill in some silence, I'll draw on my little reservoir here. And let's start with Tanya.
first question about is there a purely secular legal tradition? Depends on what. I'll speak of the common law tradition, which is the one I know best. In the 17th century, one would have said that, if you were in the mainstream of the common law tradition, that the common law is not inconsistent with any scriptural obligation. Okay? But it was, some common law theorists wanted to take a step further and say the common law was largely deduced from scriptural law. This was so questionable that few made the move. Mostly they would say it was not inconsistent with scriptural obligations. Because of the need to maintain consistency in the face of attacks by, or in the face of questions by reformers who wanted to more Christianize the common law, so the question of the relationship between scripture and common law was in the forefront. Now in the 20th century, I would argue it's far in this question of the relationship is far in the background. In certain political circles, it's in the foreground, but at least the way law is treated in law schools today and practiced, I think the role of the divine has diminished to near insignificance. So I think in the 21st century, common law can be described as a secular tradition in maybe the way the 17th could not. Secondly, I'm going to skip to your third question about if you have a legal tradition with a canonical text such as the Constitution, is there some similarity to what I was sketching out with the religious legal traditions? I think there's some similarity, but I think the differences outweigh the similarities in the following sense. One can be an orthodox common lawyer and claim that every single thing in the United States Constitution is fully a product of context and history, right? Whereas, imagine if one is working in a religious legal tradition and opens up the Gospels and says, yeah, it says Jesus said this over here. Actually, we don't believe he actually said that. Probably it was redacted 80 years later, and there was a power move going on, and this faction of the church inserted the text. There is ultimately a resistance in the divine text to that form of a contextualization that I don't think there is in a secular in the constitutional tradition in the United States. Finally, to get to your second question, I'd like to hear more information. So when you say that divinity is not an absolute postulate, what do you mean by that?
For example, one of your colleagues, where, for example, you mentioned that you assume that you equate religion with divinity, and I think that idea of a natural law system and a divine system may be something that may be more endemic to Christianity than Christian and you mentioned scripture, but I haven't heard one word of Talmud out here. And another issue I'd like to point out is that a lot of religion is based on the Talmud. The Talmud is not a Western text. The Talmud is not interpreted as a Western text. Your way of reading the Jewish tradition by imposing this notion of divinity is actually you're imposing Western Christian, Thomistic, whatever, going forward, Lutheran, Calvinist, Congregationalist, Religious, whatever. Have fun with all the Protestant denominations. You're imposing that approach to religion onto a system which I believe does not necessarily have to accept that postulate.
Right. I think I'm partly guilty of that, and let me explain why. Unlike some of our fellow panelists are specialists in or have significant training in Jewish religious traditions, I've done some writing on Protestant religious traditions, and I've been doing some writing on these Mosaic legalists. It was not accidental that they were in the talk, and how they wrestled with the Jewish legal tradition, and they're most interested in to what extent Old Testament precepts carry forward. They are not interested in the Talmud. So therefore, I didn't talk about it, but you're right. The case with the Talmud and the case with the Old Testament are different, and it is a failing of my talk not to bring it up. Right.
Okay, we're going to, Tanya, thank you, but we're going to move. Chaim.
But so I was wondering, to take really the simplest legal argument, don't you need this? And I think, yeah, Professor Ross, in terms of how different is that from the religious everyone else? Isn't that a necessity of any kind of legal argument? The second point is really just realize, I think it's relevant to talk about the common law. Both Professor Moyn and Professor Ross's description of the common law, I think, really looks very American. When it looks at the English, Australian, Canadian sort of breadth of the common law, I think one will find far more consonance with traditional common law thought categories. So I think that it ought to be tempered by an American storytelling, increasingly the regulatory state. And I think that could add some nuance to this.
Who wants to take this on before I point?
Well, no, that's a very good question. I mean, I actually didn't claim that America has gone very far towards the regulatory state. I actually think the common law, remains a big feature of American legal thought in spite of, the rise of the modern statutory regime and so on. So I don't think anything I said felt guilty of that. I think I sort of agree with you and maybe disagree slightly with Professor Ross. I think the point I was trying to make is similar to yours, that lawyers, from their internal point of view, or judges, are going to be constrained to work within the system of legal authority that they inherit. Now, they might have lots of room for creativity, but if there's some precedent that's on point or that they interpret to be on point, they must interpret it. They must distinguish it, whatever. And to me, that puts them in a situation that's analogous with all traditional forms of legal thought. I don't think there's that much at stake as Professor Ross claimed in the fact that in the common law God is dead or absent. In the following sense, there are going to be moves that you can't make within the tradition, like saying, let's just ditch the past, or let's apply some external theory. So that was my point about Posner and Dworkin, that as late as the 70s, they couldn't say, even though that's what they were doing. And so what I want to suggest, and what I was trying to suggest, is that that's because of that similarity between these traditional forms of legal thought, which continue, we really need to step outside them to understand their evolution. And that's the case I wanted to make. And I think we would have to step just as much outside of the common law to understand the choice of people in the common law tradition to this day as we would outside of the Jewish tradition to understand its evolution and history.
A quick follow-up. While I think it's true that there are certain moves that cannot be made within an internal perspective, the same is true about the external perspective. That is, if you study law from an external perspective, sociological, political science, whatever, you can't say suddenly, oh yes, this is because God said it, or this is because some transcendental power that is involved in the move. Because in fact, law is a science and has its own internal moves, and sociology is a science and has its own internal moves. So there is a similarity here between the internal and the external perspectives. And so what we need is not to move to free ourselves from these. What we need is not to move from the internal to the external. That's as trapped, but rather to try and see actually how both the internal perspective and the external perspective have their own presuppositions, and how these actually develop within a history. Or
I just want to add that actually I'm not sure that it's true that lawyers can't, because of the internal logic of law, can't make historical or contextual moves. At least modern lawyers, will argue whatever they want, to support their case. So, I'm not sure that, there's a comparison between law and religion, I'm not sure holds for modern law. And so I actually think, one should distinguish between legal academics and lawyers, and while Shai is right that kind of there are certain things that you're not supposed to say if you're doing the science of law, if you look at what lawyers actually do, I think, they'll do whatever it takes to win the case.
Right.
But it's not really whatever it takes. I mean, I was actually thinking about practice. I agree with you that we're thinking of the distinction between practice and where it's academic, but I sort of think the other way. I think you look at practice of law, right? Go in there, whatever you believe in your head, right? What you're saying is these precedents are irrespective of it. I don't care, and most often I don't know whatever contextual factors created them. And the whole, I guess we're going to the whole assumption of any, even the most basic, the most complex legal argument here is that that thing that happened a long time ago is normative here today, in our case, regardless of the difference between our context here and whatever context produced it.
So that's one side. The other side obviously would say, no, those policy arguments that make the precedent non-binding, now because it may have been useful, 20 or 50 or 100 years ago, but, utility considerations or justice or whatever mean that we should, distinguish it, for example.
Those arguments are available, but they seem to be the recessive gene.
The marginal rather than...
Marginal, right? Those are when you can't do it on the precedent, you'll go there. You never start with that. And I was going to say that to me, the edifice of law is this intergenerational transconnectional activity, which is difficult to explain, but I think necessary for the thing we call law.
Okay, Jessica.
I am fascinated by this question of the extent to which, well, whole sense of problematic from secular law and religious divine law. And throughout the course, I've followed the program and throughout our studies of the period, it's been a real, my instinct is really along with the process, that there's something really different in many ways about the study of a law that is claimed to have divine origin versus divine. I'm going to bring in a little bit more Islamic tradition. I work on in my, I guess one element that hasn't come up in discussion so far is the question of state, right? So I'm not a specialist at all in the common law, but my limited understanding, and certainly civil law, trend, that the law comes up in the context of some sort of state, right? And that it's sort of indescribable possessing. My understanding of Jewish law and Islamic law is that although there were states around, certainly for Jewish law, there wasn't a Jewish state at the time of Jewish law, and the formative Jewish law. And in the Islamic context, this state was, well, really the jurists, I mean, this is what most Islamic scholars think, the jurists were somewhat independent from the state. And a lot of the law that came up was applied by the state. In fact, the state came up with this whole other kind of law that isn't considered Islamic law, Sharia. So I don't know what that says about the intrinsic characteristics of divine law, but it does mean that there's something about the claim that law comes from God or revelation and not from just history that may have something to do with that distinction. And you can have a sort of divine, an entire divine legal system that's come up without the context of the state.
Anyone want to address that? I'll give a common law. I'll just try to suggest something for a second, which is that in some ways the common law, in positing that it comes from time immemorial, puts itself in juxtaposition to the state, because it then, right, is a resource for binding the king. And so it's in that sense before the state. So I'm not sure that we have a distinction yet, which is interesting. And just as an aside, that we could talk about. It's an important question to talk about. And generally, of course, I think we're all circling around this rather intractable, important question about whether there really is a distinction between religious and secular systems, and I guess we're going to have another panel. We're going to have a follow-up on that. So, but does anybody else want to add something to that?
I think just very quickly, the relationship between the common law and the state is, of course, itself contested, right? So, at least going back to the 17th century, which is where I know best, some common lawyers would say exactly what Professor Stone said, and then others, particularly those associated with the royal court, would say the common law is an emanation of the crown and exists only by royal origination or royal suffrage. So this is a precisely contested point.
I just want to add that kind of for legal historians, I think one of the most interesting things that happened in the last 30 years is that our definition of law, following what sociologists and anthropologists have been doing, basically there's kind of a whole subdiscipline of legal sociology interested in legal pluralism. So, legal historians have been following them and kind of trying to move the focus from the law of the state to all the other forms of normative, all the other normative structures, social norms and law created by non-state communities and their history. So that's kind of, there's been a move in the last 30 years from focus on the texts, the sources produced by government institutions in modern states to kind of interest, even if you're studying modern legal history, in communities that produced non-state law-like norms and their history.
Just one more thing. Another, connected to this, another grand concept aside from legal pluralism is the rule of law, which is typically seen as articulated within state structures or somehow binding states. And then if you have a community such as Jewish communities that don't have their own state but are in diaspora, certainly they have a rule of law in some sense. And then the question would be how to understand that and then how you feed back into rule of law theory.
Great. Let me, where are we here? Okay, should I fill in the, okay. Ooh. Okay, I see Chaim has got a semi-hand up again. Okay, we're already working on our next panel. So I'll try to bring us back, right? Just because I see a void, I'll try to bring us back at least to, I have a long list, but I'm only going to do one at the moment. And that was this legal theory as a bridge. So I want to throw out this, I'm just sort of curious about this. And that has to do with the hermeneutic turn. It has always seemed to me that underlying one of these issues between law and history is a question, is an agenda of a different sort, which has to do with propensity for change. That in some ways the historicizing of law is tied very much to some underlying notion, right? Well, now we can change things, right? We've pinpointed something, we have historical consciousness, we can locate it in time and space in a certain context, right? And then we can differentiate our context from the past context, and we can kind of free ourselves and we can change things. Now, I actually think that if that is somehow one of the big underlying sort of unstated assumptions in historicism and historical consciousness, that legal theory did in some way puncture this a little. And now I'm thinking about the hermeneutic turn. Because the hermeneutic turn, or the interpretive turn in legal theory, basically mounted an argument that said change is not dependent on making arguments from historical consciousness, right? Change occurs by the very nature of interpretation and legal reasoning, right? It doesn't need this external perspective at all. And indeed, one of the things that the interpretive turn in legal theory tried to show is that there's an incredibly dynamic notion of change that is going on. I take that to be at least one of the projects, maybe not unstated, but more implicit in something like Dworkin, in the Chain novel and all that stuff, right? I mean, this is a very dynamic theory, right, of basically change. So I am wondering whether but maybe whether we can have a little comment on that, on whether legal theory in some way did turn out to be something of a bridge for a while, and what we think about the role of a kind of quest for the ability to change, right, as part of this split between the internal and the external. Ta-da.
So I think that while it's true that we now understand that law changes even when there's no historical conscience, then the question becomes, but distinguishing between different kinds of change. So I don't think that resolves the problem. So I don't think that the secular moment or the external position is about pointing out that change takes place, but rather turning it into a matter of will. That is, that we can will the law to change. So that is the positivist notion of law as a result of the human will. So we can manipulate the law to change as we want it, and coupled with notions of how we want law to change, so that we have a specific kind of reason, scientific reason, that helps us figure out how we want law to change. So and this doesn't exist at all in sort of pre-modern context and internal perspective. So you're right. If we thought that law was unchangeable, then this would be a solution. But I think it's about different kinds of law and different kinds of change.
I would say that, first of all, I think about historical examples. Certainly, certain times, historicizing the law was a way to reform it. So, if you think about German historical school, or if you think about, the revival of Jewish law, these are examples of people trying to historicize the law. But then if the argument is that we don't need history anymore, then you have to explain why history is blooming as a way to understand law. Why has legal history, which is a sub-discipline of law, didn't really exist in, say, in American academia, to the extent it exists now, suddenly so important as, it's the methodology of critical legal studies, for example. History is the major way that they talk and think about law, and it doesn't make, so historically speaking, there's a problem of intellectual history there to see, to say there's a better alternative, a better technology to foster change, and it's, interpretation rather than history, because then you have to explain why history suddenly becomes so important for a lot of these jurisprudential schools, say in the 1970s or 1980s.
I think the hermeneutic turn was a very important event, obviously, in recent legal theory. I would fault it for not being a causal theory of the sort we would also need. So, I mean, in a sense, the hermeneutic turn illustrates one thing I was trying to say, which is that from a certain point of view, there's nothing new under the sun. I mean, the idea that change happens through the law from the perspective of legal actors through interpretation is kind of, the oldest insight within, many traditional legal systems. And the fact that Dworkin imported this idea to his legal theory is in some sense a blast from the past. What it doesn't explain, I mean, it might explain how legal actors, theorists, judges could move the law in certain directions. It doesn't explain why they're actually doing so, why they choose one pathway rather than another. My suggestion is that for that, we need this external perspective. Now, to respond to some things that Shai was saying before, that would appeal to some social theory, absolutely, which is a modern theoretical project with its own presuppositions. I would insist, though, that it doesn't necessarily have to commit us to any particular social theory. That's a big, rich tradition. There's a big debate about what the status of intellectual factors are. If we think about contemporary social theory, people bandy about the idea of the social imaginary, in which intellectual factors are in some sense constitutive of the social. And that's all still an external perspective, which would allow us to understand from the outside the ways that lawyers are working in ways that they themselves could not.
Great. More? Yes? No? Good. Then I will obviously call this I first of all really want to thank my panelists for engaging us and clearly also for stimulating the need for more panels. So that's actually a great wrap-up on the social imaginary. I mean, that I think it kind of caught it's a great wrap-up. Because this is a question that I actually do sometimes really struggle with, which is that thin line between intellectual history and legal theory. Right. It sort of, right, so that the kind of line that you place in that you're drawing is, can you access something, right, that the privileged eye of the judge cannot access, right? That's kind of interesting.
So, out of the people who worry, how many are students of the center, you think? And how many people are?
It's some slaves. Okay. Oh yeah. Yeah, that's a great book. Yeah. Yeah, I'm very interested in Right.
Hi, this is Professor Chaim Simon, is a
Right.
professor of law at
Pleasure.
Harvard.
Right.
Shai Lavi.
Okay. Yeah, that's great. That's great. Yeah, I think that's right. Yeah.
Name of
That's right. That's right. Yeah.
זה נשמע נכון, אסף ידע להגיד.
I mean, you could argue that kind
אסף
of
הוא מומחה
post-Enlightenment
להיסטוריה
traditions
אינטלקטואלית.
construct an image of their enemy, which turns out to be really influential. Posits the centrality of God when in fact that was kind of a decentered belief.
Here we go. Opposed from the inside. Got him. Yeah. And he goes on about this. They don't mean that in a friendly way.
He's right.
How does, yeah, but how does he know this? This was fun.
Yeah, it worked well.
I loved your point, but like in the external, there's certain things you can't make. You can't say, "Oh yeah, there." That's because God came and told us to do. That won't work, does it? Sociology.
Hi, Simon. I'm a fan of your stuff on Mishpat Ivri.
Okay. I'm not doing a lot of Mishpat Ivri right now. But
Yes.
The truth is, Duncan Kennedy
Hey.
wanted to read it.
Wow, so I don't think so.
So you're doing.
Oh,
so you're.
sorry. What's the date today?
Exactly. What that doesn't matter.
3/20, yeah, 19 or
There's a
something.
guy there doing.
Okay.
stuff.
Let me see that I
Uh,
can. 110.
There's a
Yeah,
legal
okay.
historian.
So wait, how am I
Um, who's doing stuff on Kelsen? Is there something? There's Elizabeth Kolsky who's doing Indian history. She's not at law school. Yeah, she's in the history department.
what no one disagrees in that debate that
Who's
there's
doing-
something
who's doing
called
legal
modern
history?
secular historical.
Have like an official
Debate
legal
about
system.
how we got there. And so Yerushalmi says there's the sacred and that has to go away.
Ancient law. I mean, ancient law.
From the side says no, the sacred.
So I don't have a.
So no one disagrees that
So I may have kind of
modern
thought of
historical
somebody else.
scholarship
Yeah.
is
Elizabeth Kolsky is actually somebody who's doing law, but she's not.
Meaning customary.
Indian.
So
Says
when
Indian.
you say, you know, you tell me.
right.
Yeah.
Yeah,
That's a long time.
Well, yeah, that's right. So that's what I mean. He accepts certain aspects of Yerushalmi's view, like there's something called modern historical that's different. That kind
So
of
actually, what I should have said to this, I don't know if you didn't say it, somebody else said, kind of, I don't think that Jewish law assumes a state. I'm actually looking, I was seeing something nice in the archive. I went to the Center for Jewish History. I'm doing non-state taxation right now. I'm interested in tax systems that don't assume law, courts, sanctions. Because the Jews in Palestine actually had a system like that in the 1940s. They actually raised a lot of money. Yeah, voluntary tax system. So actually, what I saw, I saw documents of the Jewish community in Minsk. There was Jewish taxation, but they were basically tax farmers of the Russian state, and kind of they used the Russian police. So yeah. But then, but then kind of there was a transformation because they couldn't do it in 1940s Palestine. They didn't do it, so basically they were using shaming. That was a sanction. Publicity, shaming, stuff like that.
then there's a debate. If
The state, you don't assume the state. You kind of, a lot of the communities in the diaspora do assume the state and use the state in a mechanism.
I think
create.
thought that scripture speaks the language of human beings is the source of the later idea.
Yeah.
Is not at all right.
Gotten to that.
In other words, what I'm fascinated by is that we have the system of civil law,
It's a dialectical.
which never applied, really, but sort of
Well, but there's Spinoza.
No, it's mostly criminal law. Kind of civil law would be applied because kind of, in
Yeah, but not in the way it's
internal.
written.
I mean,
Yeah, obviously. it's
Well,
that.
but that's the point. In other words, so whether
Yeah, but there's a distinction between law in the books and law in action also in kind of modern legal
there's
system.
always is, but I think
Yeah, it's
much more
probably,
drastic.
Religion is the dialectical source. It's not
Right,
like
so
there.
So okay, yeah, that,
I mean, there's a break.
yeah. So I've kind of the book that kind of the article ultimately became part of is about law as kind of it's about law and identity. Law not as a way of resolving disputes. Law is not as a tool of power. Law is not an efficient mechanism. No, it's English. It's called Law and Identity in Mandate Palestine. It's about law as kind of a cultural artifact. That kind of,
Right.
But it's not just about Jews, it's also about the Arabs and British
Well,
in Palestine. I think
the problem arises if you sort of
arguments
say, well,
about law as a way to declare, I'm X and not Y and kind of define myself. That's the use of law, and kind of you're not really interested in kind of as a kind of it's
regulatory.
Yeah, you're not, it's not
because
instrumental.
because these are
I think
Tool.
it's definitely true.
that is kind of the existing
Lots of Jewish law.
Yeah. I actually think it's also true about modern kind of. I look at British colonial law, and a lot of it is kind of we are going to enact. There's legislation we're going to enact as part of the civilizing mission. We declare that we are British and therefore civilized, and the law deals with all sorts of
I don't think
cultural
he would-
practices which are abhorrent and of the natives, but we're not going to enforce it. We're going to report it to the League of Nations and kind of, and it's a way to bolster and legitimize our rules.
What I'm trying to go is connect that to
its suggestion is that there's a Jewish contribution, and who knows how big it was to take it out. Well, I mean, if you take Spinoza,
there's a lot of people because of the cultural turn in the last 30 years, a lot of people have suddenly become interested in non-instrumental views of law. So my book is basically says something that a lot of other people are saying. But I totally agree that suddenly you see it in Jewish law more than you see it in other places.
Right, it's a matter of degree, but I think to me the combination of the and the strong ethos of the is
but I don't. I also, it's kind of. I think it exists in every kind of. Cover. And also, I think it applies in every kind of legal system to a different degree.
And there's no idea.
I'm not sure about that because